Dumelang. Good evening, welcome everyone. Let's see. Hi everyone, welcome. Hello. Let's see. Go live. Guys, I'm sorry, I'd love to go live with the people that I'm seeing on the request, but I'd have to just wait for our guest. Dumelang, hello. Hey. How are you? How are you guys doing? I hope the week has been kind. Khomoto, I see you. Let's see. Okay. Over there. Ah. Thank you. I can see that. Bongosi. Right. Rar.
Hey, Abuti, Uzela.
I'm well. How are you, brother?
Man. Can you see me?
I can want us in the now. When I'm born.
Yeah, you want to stand.
Little how Cariano.
Yo, you want to sharp.
Okay. No, Kalebu Khawara. Kawana people are joining. Maybe. Can you guys see me properly? My head, everything?
Yeah, I guess I'm one.
Yeah, no, I would clear that. Now I'm born. I'm on my screen. I'm not. I'm literally just seeing from here. But if one amodimu Husian.
No, I guess up. You want to stand.
Okay, great stuff. People are joining. Welcome everyone. Thanks for joining. I know it's a Thursday. People have plans, but you've decided to join. Thank you, Amache, for confirming that you see me well. So today we're going to maybe let's just shoot straight because we really have a tight schedule and we really want to just push as much as we can. Without wasting time, thank you everyone. I really appreciate you making the time, joining these IG sessions with Dumi. And you would recall last week I was in conversation with Clement, who is a family attorney, pension lawyer, senior lecturer at Wits, and he's currently reading for his PhD at UCT, and he writes, I don't know, you just have to Google Clement if you want to know more about him, but he's a practicing attorney and he's gladly offered to do these sessions for this month, focusing on family law. And today, what we then did from last week, we just had an overview and spoke in general about family law concepts relating to lobola. But as part of our Women's Month celebration and giving back, Clement and I subsequently had a discussion, and we then thought that we should have a focused session. And this is one of the four in relation to the focus sessions. And today we're going to focus on parental rights. And that includes issues related to maintenance, issues related to custody, and the likes. And given obviously the time and how focused these sessions are, I'm going to propose that Clement starts off in the next 25 minutes, take us through the theory, for example, on what parental rights and responsibilities are, and then we use the next 25 minutes for questions that I've received, and some of these questions are going to come out as the session continues. I hope that makes sense and everyone is happy with that. I will look at the comments and see if people are happy with that. So literally doing the first 20 minutes or so of high-level theory on parental rights and responsibilities and covering key concepts. And thereafter, we will then do your questions that came through and some of the practical issues that you've raised and maybe that Clement has seen in practice and what he's come across just on this particular aspect. Are you guys happy with that? Okay, I take no comment as, okay, yes, Ms. Lebu has responded. So she speaks for the rest of the 62 people that are on live. Obushe, thank you also for confirming. Dukulu, thank you so much. Lubuani, thank you. Anna, I appreciate your response. Everyone, thank you. Clement, I'm just going to hand over to you so that you could just take us through high level on parental rights and responsibilities. And then we are at least at 18:30 or 18:29. We then move to the Q&As and give people the opportunity to ask questions. Thank you. Over to you.
Thank you very much, Tumi. And I think, as per tradition, I would think one has to put a disclaimer that what we are doing is not necessarily providing advice, nor is providing any expert analysis of the law. And we do welcome, because we are well aware that there might be people who are practicing on the field and they may have views, and we most certainly welcome them, even those that are contrary perhaps to what we are going to say. They are most welcome, and we need to really engage on some of the things that they want to raise. Generally today we are dealing with child-parent relationship, but from a point of view of a romantic relationship arising or emanating from what we discussed last week. So the applicable act in what we are dealing with is the Children's Act. And when you look at this act, it has a chapter that deals with parental responsibilities and rights. And the wording is important because it was deliberate. It is not parental rights and responsibilities. It is parental responsibilities and rights. And it starts with responsibility for a very important reason, that we are moving from an era, because this act came in 2005. It changed the dynamics from what was usually called parental authority, where parents had authority over their children. Hence, you used words like, you have authority, therefore you have custody over the child. I mean, in criminal law context, when you're talking about custody, you lock somebody in and you control the person's movement. That is custody. That person is under custody. And to some extent, that's how it was understood, even in family law, that a child is under the custody of the parent. The parent can control everything that the child does. And of course, the other parent will have what they call access to the child. So that was the terminology generally that was used when this concept of parental authority, which is a common law concept, was in play. In 2005, we saw a shift in paradigm, wherein a new concept came in, the concept of parental responsibilities and rights. And the thinking was, parents have responsibilities over their children. And with those responsibilities, there are certain rights that comes with those responsibilities. So we look at what parents should do, or what parents are expected to do in relation to children. And once they are doing that, now we can start classifying the rights, if any, that they have in relation to the child. Now, you look at Section 18 of this Act, what it does, it basically gives 4 parental responsibilities and rights. In other words, there are only 4 parental responsibilities and rights. The first parental responsibility and right, it is the right to have care of the child. A lot of people are saying the word care has replaced the word custody. That is not entirely true. But when one looks at how the courts have progressed, because the legislation does not necessarily say custody has been replaced. But when one looks at the definition of care in the Act, it is more broader than what custody used to be. In other words, apart from controlling the child, there are certain aspects that comes into play in relation to the care. It's much broader. It involves the child's development. It involves the child's involvement in the child's life, extramural activities. All these things, they are encompassed under the word care. It is much broader. Now you move on to the word contact.
Yeah.
And that becomes an important concept as well, that the other parent has a right to contact the child. So now that means parents have the right to care and to contact, or to have contact with their children. So that is the first. That is the first parental right and responsibility. Now the second one, it is in relation to, no, actually I'm putting it wrongly. You have care, then the second one is contact.
Contact.
Now contact has to be the other. If one parent has care, the other parent should have contact with the child. In other words, it is important that the parent who does not have the care of the child allows the other one to have contact with the child if the parents have separated, so that the child can actually have the benefit of the love of both parents. And when one looks at family law, it has shifted from the care of one parent, and now we are trying to advocate for the care of both parents. I know there's a lot of questions relating to that. The third parental responsibility and right, it is guardianship. You find that apart from care, which is a day-to-day arrangement and development and whatever of the child, that's fine. Guardianship is more about transactions relating to the child. If the child wants to get married, then the parent must consent to that marriage. If the child wants to be taken away outside the country, now the parent must consent to that. So guardianship is more about the legal implications and transactions regarding the child. And you find that it is quite different from what care is. Guardianship, a parent who does not have the care of the child or who does not have contact with the child can still have or become a guardian of the child. And from time to time, that particular parent would have to be consulted in relation to things that are happening in relation to the child. Now, the fourth and final parental right and responsibility, it is in relation to maintenance. And this is the only parental right and responsibility that is not actually defined in the Act. When one looks at maintenance, we are looking at, it is broadly as well considered, because it relates to the finances, it relates to the provision generally of things that will enable the child to grow. You talk about clothes, you talk about food, that is actually the maintenance that we are talking about. So those are the four parental rights and responsibilities that arise in terms of the Children's Act. Now, when you look at this Act, then one has to go to other sections of the Act. Section 20 deals with parental responsibilities and rights of married fathers. In other words, it outlines when two people are married, what are the rights that the father who is married to the mother has in relation to the child. And it defines that, look, at the time when the parents are married, the father automatically will have those parental rights and responsibilities that will arise, meaning that care, contact, guardianship, and maintenance. Those four, the father will have those rights in terms of Section 20. Section 21, it is more interesting, and I think most people have questions in relation to it. The parental rights and the parental responsibilities and rights in relation to unmarried fathers. Now, people are saying, if I am not married, I have a child, I don't stay with the mother's child, what are my rights in relation to that particular scenario? Now, Section 21, it says basically that when the father was in a permanent life relationship with the mother at the time when the child was conceived, then the father will have automatic rights towards the child. And it goes on to say, look, if that is not applicable, then if at any time after the birth of the child, the father identified himself as the father, or maintained the child or attempted to maintain the child at the time of birth, then the father will have automatic rights and responsibilities that are outlined in terms of section 20, in terms of section 18. So section 21 is more important to those fathers who are not married to their mother. So there is a criteria that is followed in that section. So if you fall within one of those criterion, then you will automatically have those parental rights and responsibilities.
Yeah, Clement,
now,
I think, sorry, Clement, and sorry to interject. Just again, if you were just to rehash it once more, because I think it's very important, and you're absolutely right insofar as some of these questions being based on that. So if you could just touch on it on a one-liner once more, and then you can move on. Sorry to interrupt.
All right. In relation to section 21, which deals with unmarried fathers, there is a criteria that is used in relation to the children. In order for that kind of a father to have parental rights and responsibilities, it is important at the time when the child was born to ensure that he or she was living in a permanent life relationship. In other words, they were cohabiting together, but they were not married. So at the time when the child was born, if they were cohabiting at the time, then the father will automatically have all the rights and responsibilities that we spoke about.
Yeah.
Secondly, if they were not living in a permanent life partnership, now the father, it would depend on whether at the time when the child was born, did the father identify themselves as the father? If he came forward and said, look, the child has been born, I'm the father. By so doing, he will automatically get these rights and responsibilities. If he doesn't do that, but nonetheless, when the child is born, start giving money for maintenance in part or in full, or at least, because sometimes fathers can try and mothers can say, oh, the family of the mothers, we don't want your money, this is not your child, and whatever. So if he can show that he attempted to provide some form of maintenance at that time, then the parental rights and responsibilities will be accorded to him. So it is an important section in relation to fathers who are not residing with their children, but they are denied the right to see their children.
Yeah, and thanks for that. And one question which we can deal with at the Q&A is why is there a distinction between married and unmarried fathers in circumstances where children in any event are receiving benefits, and why should we be distinguishing on those spaces at the end of the day?
The distinction is simply because of people's lives, because if the father resides with the mother, there are no issues. You go to work, you come back, you find your child there. There are no restrictions. But when the father does not reside with the mother, there are restrictions. When can you see the child? You need to go to court to fight to see your child, and all those things. So the nature of the relationship between parents, it inherent in that kind of relationship, it will distinguish between those two. Because now if I'm not residing with you and I want access to my child, you can say, oh, you have not maintained the child, you don't care about the child, you have not done anything to show interest in the child, you don't have to see the child. Because family law matters are very emotive by their very nature. And in most cases, people use the child to punish each other or to be spiteful against each other. So it is important to have those distinctions and attach legal consequences to ensure that whoever is on the right is able to use the law to safeguard their rights.
100%. Thanks for that, and thanks for making that distinction. We are noting some of the questions that are coming. I'm seeing them. Leratu, I see your question. Togum Tlalos, thanks for just keeping these high-level notes going. It's appreciated. You can continue, Clement.
Yeah. Now, when you look at section, okay, there are, let's say maybe if the father has not yet attained parental rights and responsibilities automatically, there are various ways in which those rights can be assigned to the father. Like, for instance, if the father doesn't fall in any of the category that is used in terms of Section 2021. Other provisions of the Children's Act, they allow the father and the mother to conclude an agreement wherein the father will be, or wherein the father will acquire parental rights and parental responsibilities and rights through agreement, if they agree with the mother. Sometimes over time, attitudes change. The father can come off the face and say, look, I see the evil in my ways. I don't think I've done right by the child. I want to make sure I want to be involved now. I want to do things differently. Then at that time, they can actually agree that, look, we are going to assign rights to you by agreement. If that doesn't work, Section 23 allows the father to apply to court so that these rights can be assigned to him. Like, for instance, if the father did not acquire rights by Section 21, Section 22, and you find that he wants to be part of the child's life, he can actually go to court and say, look, I want to be part of my child's life, but I'm denied care, for instance, or I'm denied contact, for instance, or I'm denied an opportunity to maintain my child, or I don't have guardianship. So Section 23 will be the most important act as a provision in the act that deals with both contact and care with the child. So a substantive application to court can be made in terms of that provision to ensure that the father can actually acquire parental rights and responsibilities. But not only the father, there can be somebody who is interested in the well-being of the child, who is not necessarily the father or the mother. It can be a grandmother or somebody who is interested, who can see that the child needs that kind of care. That person can actually apply to court to be provided the right to care for the child or to have contact with the child. So Section 23 is an important tool for attorneys in particular to ensure that they apply to court to be assigned those particular rights.
Thanks,
Section 24.
Again, yes. I apologize for interrupting. There's just this, and sort of a perception of some sort that we're talking about the rights of the fathers and the rights and whatnot. Perhaps maybe if you could just address the default position in relation, because now no one, at least for now, in Women's Month, talking about what are the rights of the mothers in terms of access and whatnot. And perhaps there may well be a common law position that people are not of the default position. And if you could just touch on that.
Mothers generally, by operation of law, they because they give birth to the child, and they are in most instances they reside with the child. So generally they will acquire parental rights and responsibilities in any event. So because they will be with the child. But there might be instances wherein after the child has been born, the father is able to apply successfully to court and is provided care of the child. In other words, the father will reside with the child. Under those circumstances, the mother can actually apply to court to have contact with the child. And of course, if the child resides with the father can also apply to court to have the mother pay for maintenance. So, but generally, like you said, it's not necessarily a default position, but it appears to be, because the mother gives birth. In most instances, mothers resides with children. So under those circumstances, you find that it so happens that mothers do not have to go to court to protect their own rights in relation to children, but they most certainly go to court to protect their children's right in respect to what they deserve from their parents. And those are two separate things.
Great stuff. Thanks, Clement.
Now, when you look at Section 24, Section 24 deals in particular with guardianship. And any person, and this is important, any person, not a father only, not a mother only, any person who's interested in the well-being of the child can actually apply to court to have or to be granted guardianship of the child. Because remember, the High Court, it is the upper guardian of all children. So as the upper guardian of all children, it can assign guardianship to whoever wishes to have guardianship over the child. But of course, it will be guided with what it is in the best interests of the child, which is the general principle that is applicable in matters that have to do with children. So basically, those are the sections that can be used in different scenarios to ensure that at the end of the day, anyone who has interest in the child can actually apply to court to have any of those parental responsibilities and rights assigned to them. And I think one last thing that I really want to wrap up with, because there are a whole range of things that I left out in relation to the discussion, but I think these are at the core of the debate. Section 28 of the Children's Act, it enables a person who is a co-holder of parental rights and responsibilities. In other words, a person who has been declared to have those rights, or a person who has acquired those rights.
Yeah.
For that person to apply to court for the termination, for the extension, for the suspension, or even the restriction of parental responsibilities and rights of another person. Like, for instance, if you feel like the person who is a co-holder of these rights is irresponsible, does not have any regard to the child, his or her conduct is contrary to the well-being of the child, you can actually apply. Like, for instance, I think there is a picture that, or a video that appeared in social media, and it was all over the news, where a mother was seen giving a child a savannah, for instance, a 2 or 3 year old, a savannah. Somebody might have been really touched by that kind of activity, and he can say, look, this mother is not fit to care for this child. In actual fact, I am going to apply for parental rights and responsibilities, and I'm going to ask the court to terminate this person's parental rights and responsibilities on the basis of the welfare of the child. So it is possible to apply to terminate or the person's parental rights and responsibilities, or to even extend your own, or to suspend them. So you can actually bring an application to court to have those either extended or terminated.
Yeah. Great stuff.
I think in a nutshell, that is the basics as far as parental rights and responsibilities are concerned. Now, in relation to maintenance, the Children's Act is not necessarily heavy on the issue of maintenance, because maintenance is dealt with there is a specific act that deals with maintenance, the Maintenance Act, which really deals with issues relating to maintenance, the procedure for maintenance, circumstances under which one can actually apply. But I want to underscore this fact. Maintenance is not the obligation of fathers. Maintenance is the obligation of parents in relation to their means of income. In other words, maintenance is proportional. It's not a foregone conclusion that somebody has to pay maintenance. Everyone who has made a child must pay maintenance. But the contribution must be proportional towards the person's earning. Like, for instance, you might find that somebody is earning 3,000, the other one is earning 30,000. So if you need to maintain 50-50, 50% out of 3,000 might be way less than 50% out of 30,000. But it needs to be 50%. Somebody cannot come and say, but you are paying 3,000, therefore I need to pay 3,000. No, you need to pay 3,000 of your own money, which might be 30,000. So it is important to have regard that maintenance is an obligation of both parents.
Yeah.
Not necessarily an obligation of one parent as opposed to the other.
Good one. And we are seeing that, right? And one on this, so someone is asking on the maintenance issue, for example, where the parents are unmarried and no longer together. So a situation where at times you find that I left my wife, or she's moved on, or I've moved on, for example, and whether that duty of maintenance still supersedes or continues, for example, despite us not staying together. And I'm sure that the answer would be yes there, but maybe you just want to qualify that aspect, Clement.
I didn't quite get that. Maintenance for the child or the spouse?
She's talking about the child in particular, where the parents are unmarried and staying and not staying together.
Maintenance is a common law duty. It is just that it has been codified, but it's a common law duty. Whether or not you have a good relationship with the person that you dated, whether or not you are still in a relationship, it's immaterial in relation to maintenance. The fact that the child is still 18 years and less, is still a minor, you have a common law duty or a common law reciprocal duty to maintain the child. So both of you are obligated to maintain the child. So even if somebody can go and reside with or have other children or marry somebody else, the responsibility to maintain the child up until they reach 18 does not go away.
Yeah. Great stuff. Thanks, Clement. I'm looking at the time. It's 18:34. I just want to take these ones and take the ones that came due to or as a result of the Q&A that was up the other day. One from Lerato says, or Lerato, can step parents be responsible for maintenance if the biological parent father is unemployed, but the other parent mother is employed? I don't know if you can see that, Clement, on your screen. I've tried to bring it down.
I don't. I see different ones. But nonetheless, unless those parents have adopted the child, like if there is a formal adoption, then they will have a duty to maintain them. But if they have not adopted them, the duty to maintain will be with natural parents. And if not natural parents, then grandparents or next in line. So it will be in relation to bloodline, unless any of the step parents, in actual fact, they adopt the children. But what normally happens is people who marry each other, they take children as their own in any event, and they by and large they support them. But in law, they are not obligated to do that.
Great stuff. Thank you, Clement. And another one is, I've separated with the baby father. The family of the father does not want me, and I'm scared to give them the child to take to his family. Can I keep this child and not take them to the family, for example? And this is a mother who is worried and saying, I keep a kiwi and it's not safe. So would I face any issues, for example?
I mean, those issues, they happen a lot. Now, the question will be, are they not interested in you, or are they not interested in the child? Or the other way, are they interested in the child as opposed to you? Because they might not necessarily want you, but they may want the child. But it's not really about them. It's about the father. What is the father's attitude towards the child? If the father is not given access to the child, the father can use some of the provisions that we have dealt with to make sure that he has contact with the child. And the court can describe, or it can prescribe the parameters of the contact. It can say, look, you can take a child over weekends and stuff. And if the child is with the other parent, you can actually go with them to their families. And there will be nothing that will stop you from them, because the father's family is the child's family in any event. So you cannot really stop them. But it will depend on the circumstances. But if the father is serious about seeing the child and he meets the criteria that we have outlined, then he can actually apply to court and he can be assigned those particular rights and he can get the child. But that doesn't mean that he needs to take the child away from you.
Thanks, Clement. And thanks for the question. One of those also on guardianship. Can a natural guardian lose their guardianship or the right to exercise any powers, in inverted commas, that come with being a guardian in respect of their child?
Yes, in terms of Section 24. If there is any person who meets the criteria for being stripped or for the parental responsibilities and rights to be terminated, then definitely, even though they are a natural guardian. Because if your natural guardianship is contrary to the best interest of the child, because remember, the Children's Act is child-centered. It is more about the child. I mean, if you are a natural guardian and you drink whole night, Monday to Friday, you don't come home, the child is left to starve, and there's no proper care, the child is not going to school, and all those things. Obviously, you're going to be stripped of your guardianship, because really, you are not being of any assistance to the child. So any person who has the well-being of the child at heart might apply for your termination, and might use Section 23 in particular to apply for the care of the child. Then they can care for the child, and they can subsequently apply for the guardianship, and they can be the guardian of the child.
Great stuff. Thanks for that. There's another one that I like, and I think it's similar to some of the questions that were asked here, is if a mother earns more than the father, can the court decide for the father not to contribute? And I assume here this is in relation to maintenance, for example,
yes.
Or in circumstances where, for example, the father obviously earns lesser than the mother, but can the court decide for the other party not to contribute?
No. The court it does not have the right or the discretion to prevent any parent from contributing to the maintenance of the child. As I said, you contribute in line with your earnings.
Yeah.
If the mother earns 30,000, for instance, and the father earns 5,000, and the father can only afford to contribute 200, that 200 will still go a long way in maintaining the child. So the court cannot say, no, keep your 5,000, man, we don't need it, because the mother has this covered. No. The thing is, you have a parental duty to maintain the child. And the fact that you earn less, it does not absolve you of maintenance obligations.
Yeah. Great stuff. Thanks, Clement. And then another one is, can a father who doesn't want to be part of the child's life sign their parental rights or responsibilities away forever? You know, those types are clear. Yeah.
I am not sure if any person can apply to court and say, I don't want to be part of the child's life, because you're going to be forced through maintenance that you may not want to be, but you have a duty to maintain. This is a legal duty. You may not want to be part of the child, but you have a duty to maintain the child. So you're going to be forced. You cannot go to court to absolve yourself from the duty that you have. So in most instances, people just go AWOL. And if somebody has went AWOL, it's all about being found and being forced to maintain the child. But somebody cannot go to court and say, look, I'm not interested in this child, I cannot maintain. The fact that you brought this child onto this earth, you have an obligation to maintain this child. So you're going to be forced to maintain the child.
Yeah, and I guess also it answers Nontobega's question that, can I take the father of my child to court for maintenance, even though he's not part of the child's life? And I think that's exactly that. You know,
of course,
it doesn't really matter whether is part of the life or not. One of the questions also that, and I'm seeing some of these questions, and thanks for bringing them up. We're asked to add whether can absent fathers, who sometimes are called deadbeats, relinquish their parenting rights forever, as an example. And these are people who are not in the child's life, who really have not shown an interest. Effectively, can they be seen by conduct to have acquiesced their rights to the child as one of those things?
I mean, at the end of the day, one would think that, I mean, people do that all the time. They just disappear. You know, they just decide to disappear. But the thing is, the fact that somebody has not shown interest in the child's life, it does not absolve them, in particular, from the maintenance issues. It will be from the attitude of the other parent, because some parents will say, look, I cannot force this person to maintain their child. If they don't want to maintain them, then that's fine. But there are nuances to it. Sometimes people take those routes because they are denied to see the children. It is not a defense not to maintain the child because you are denied to see the child. If you are denied to see the child, there is recourse, because you can actually take the mother to court so that you can see the child. So that is not, you cannot balance that out with not maintaining the child. You cannot say, I don't see the child, therefore I won't maintain the child. No, it doesn't work like that. You can still be forced to maintain the child. And you can actually try to assert your own rights and say, I want to go to court so that my parental rights and responsibilities to have contact with the child are restored.
Yeah. Thanks for that. At what age does the child maintenance stop?
Ideally, I mean, in terms of law, one would think, in terms of law, it is 18.
Yeah.
But there is a debate now in relation to dependent children. In other words, after 18, you need to go to university, you need to do all those things. Those kind of children, they can still take their parents to court for assistance on the basis that they are still dependent. Because in reality, I mean, 18, people who are 18 are not necessarily going into the job market. They are still finding themselves. So parents, in most instances, they will assist. So there is a lot of cases that demonstrates that dependent children can actually force their parents to assist them to get to a point whereby they can be self-sufficient.
Thanks for that, Clement. And I mean, one of the things maybe
sorry to me, there is a question. What happens if the father does not give consent to travel outside the country? This is important because I'm actually interested in this kind of topic because I'm currently researching on it. There is something called child relocation disputes. Wherein, and I know for a fact that this is not the question that this person is asking, but I'll try to answer this question in any event. But before I do that, sometimes you find that when people separate, one person will want to move from the place where they used to stay to a place which is a little bit distant from that place. Like, for instance, somebody who stays in Joburg might say, look, there's no reason for me to continue to reside in Joburg. I found another job in Kimberley. I want to go to Kimberley. Or somebody can say, look, I want to go to London and I want to go there with the child. In other words, I want to relocate with the child. So at the time when sorry, let me just see there's somebody knocking. Let me just see who's
no worries.
Just give me a minute.
Sure. Thanks everyone for your questions. And
I have a session. Yes. Sorry about that to me.
No worries at all. But you're stistill talking about the issue of relocation quickly.
Now, you find that under those circumstances, Section 18(3)(a) or 3C of the Children's Act, it says that when you want to take the child where the child currently resides, you need to have consent of the other guardian. In other words, if you want to take the child outside the country, you must have consent of the other guardian of the child. Without that person's consent, you cannot take the child away. So similarly, even in child relocation disputes, if you want to move away from, you need the consent of the other parent. But if the other parent refuses to give consent, you can actually make a substantive application to court so that the court can grant access. Because remember, the court is the upper guardian of all the minor children. So the court can grant access, consent for you to move to relocate the child from the current place to a different place.
Yeah, thanks for that, Clement. Can a father stop paying maintenance of a child while waiting for DNA results? I think obviously this requires more, but you know, it's in a situation where there's a dispute whether you are the father or not, and you get told that you are the father.
Look, this is very nuanced in a sense. You really need to look at it very broad. I don't think the law is quite clear on it, because one way of thinking of it will be you refuse to pay maintenance, you go for DNA, the result comes positive. Now, the mother will say, look, there is maintenance that was not paid. You need to pay the areas. So it depends on how you look at it. But I mean, practically somebody can stop and say, look, this is not my child. But perhaps the advice will be pay up until the results come. And when they do come and you're not the father, you cannot be forced to pay because you don't have those rights over that child. The father's child, that child's father must be found. But we have found cases where there are cases where if a person has maintained the child for a long period, there are instances where some of the courts have tried to strike a balance to say, but the child has been in a position whereby he has been maintained by you. What is the rationale to stop now? But there is no, the law is not quite clear in that particular aspect. I think it is still a matter that can be debated. But in all honesty, if you're not the father of the child, you don't have, or the mother of the child, you don't have the obligation to maintain that child.
Yeah, and Clement, just on another issue, where for example, you know, fathers in particular refusing to give mothers copies. So you want to go register a kid at school, they are not together anymore, and the father is just basically being difficult and spiting the mother and basically making a mess.
You know, this question, when I saw it to me,
yeah,
it really concerned me.
Yeah,
because there are various acts that deal with children's education. Like, for instance, we have the National Education Policy Act, and we have the South African Schools Act. And those acts are quite clear that schools should not have criteria or come up with requirements that will end up not assisting children to register. It is important.
yeah.
So the school, even if it is in their policy, the school cannot demand that you come with your ID and the ID of the parent. Of course, we understand why they are doing that. They want to make sure if you don't pay, they can actually go and garnish and do all those things.
Of course.
But in law, at least as far as these acts are concerned, because these acts are clear that even if the child does not have an ID, you cannot stop that child from registering. So it is important to note that if the father doesn't want to give an ID, that is not a bar for the school to register or to admit the child. The school should still admit the child. And of course, the paying plan must be made as to who will be responsible for paying the fees. And if the father is part of paying the fees, and of course, that is part of maintenance, what the mother can do can actually take the father to court to try to force the father to contribute towards paying the fees. But the issue of an ID should not be a bar from the child to be admitted in a school.
100%. Clement, we have 9 minutes, and we can do one of two things. Close this session and then open it up for until quarter past, immediately go on and basically do a mini part 2. I know that most people are unlikely going to join, and we are mindful of data also and address those questions that are remaining, because at exactly on the dot or at 7:05, it's going to end and we're not going to be able to have the rest. And I'm proposing that either we close this down now and then we deal with a question from Tukulu, one on relocation, for example, and one from Vanessa talking about claiming back maintenance after you find out that your child is not yours years later. And maybe in as closing that other aspect is the fact that the courts continue to fail mothers in particular. You know, it's a daunting process. Going to court, being dehumanized, the court officials not helping and stuff like that. You know, as part of the reform and what you are doing, it's part of the research commission. What is it that you guys are looking at, and how can it be more humane, in particular to mothers? So that's the proposal. We close it out.
Yes, I agree with that. I think it's a more safer one. Let's close it up, then we reconnect.
All right, guys, please reconnect. We're just going to address the 4 questions that are coming, and we will then close this session on parental rights and responsibilities. It would be great if you were to join us, and we will then finalize those. Please do join and put your questions. It's going to be 10 minutes, if not 15, not more than that. We are mindful of data. We are mindful of your other commitments. Thanks for now. Let's connect in the next 5 minutes. 2 minutes rather, actually.